Alrighty, good evening, everyone. Welcome to week 11 of administrative law. Very much, at the end, at the business end of the term. So, good to have you with us. Hopefully, the exam preparation is going well and it is well underway. A little bit of housekeeping before we get started. The reflective discussion assessments have all been marked. I was hoping to polish off the last little bit of moderation this afternoon and didn't quite get to it. So I'll finish that off tomorrow morning, and then those grades will be released. I'll make a post on Moodle once the grades are visible, but you'll have those marks um, tomorrow morning sometime, and then you'll well and truly know where you're at going into the final exam. We do have a couple of exam hints. I'll save those towards the end of the tutorial just to milk the interest. But that's coming along. But hopefully, your exam preparation is well underway. Tonight's tutorial is our very last ground of review. We're looking at unreasonableness. And unreasonableness is a good one for us to sort of end on. It's one that it's one that's really good in an academic setting because you will have seen with these tutorial questions, I kind of throw a lot of problems with the decision at you, and so cumulatively that ends in some very poor decision making, and that makes things easier in terms of unreasonableness and arguing that no decision maker would have made this decision. No decision maker is this bad to have made this many errors in the decision making process. In the real world, it's one that we tend not to see all that often. That's not to say that decision makers are perfect. They make mistakes, of course, but it's a very high threshold to reach to argue successfully that no reasonable decision maker would have arrived at that decision. And so that's something that I do want you to sort of keep in mind as you consider this topic, and especially as you think about assessment, but then also potentially beyond. You will get, I suppose, an inflated sense of this ground review and how often it comes up and how useful it is. In reality, it doesn't come up all that often, but it's a tool in the toolkit, and it's really important to be aware of it and to be able to make use of it when you do need to. But so with that in mind, thinking about the ground review in general, it is really important to keep in mind that when we're talking about unreasonableness, we are talking about a very specific standard in terms of no reasonable decision maker would have made that decision. It's not just, oh, I don't agree with this, therefore the decision maker is being unreasonable. It's not just for any old decision that we disagree with. It's for that really specific and narrow class. And so even if let's say in the exam, let's say you thought that the decision was unreasonable to that standard, and that no reasonable decision maker would have made it. It's also really good to include in your discussion an acknowledgement of just how high the standard is to achieve that. And so just thinking about, um, yes, in your discussion, you might find that the decision has been unreasonable, but just keeping in mind and including in your discussion an acknowledgement that it's not likely to come up, and it's not likely to be a home run winning argument all the time. That being said, in cases of unreasonableness, we tend to find sort of two I guess there's two pathways to unreasonableness, or thinking about unreasonableness. The first is where there's maybe only one problem or a limited number of problems, but they're just absolute howlers. It's just catastrophically poor decision making. And so no reasonable decision maker would have made it. So thinking about the decision in Chan where the decision maker just looked at the wrong file, you know, it's just completely unreasonable. There's just no basis for that. Um, so a decision can be unreasonable in the sense that there's just one absolutely fatal error, or a decision might be unreasonable through the cumulative effects of lots of other problems. And so when you think about, the other grounds of review that we've looked at in this unit, it might be the case that the decision maker didn't afford the person who's affected by the decision, they weren't afforded natural justice. And then on top of that, they might have considered an irrelevant consideration. And then on top of that, there might be issues with the authority to make the decision. And it might actually be that any one of those grounds of review are successful, but the decision maker wasn't necessarily unreasonable in having arrived at the decision. There might have been a problem with natural justice, but other decision makers might. It's conceivable that they would have arrived at a similar process. Um, the irrelevant consideration, yes, it was a problem, but you could see other decision makers falling afoul of that as well. And so any one of those might not be unreasonable, even though the decision is still invalid. But the cumulative effect is would a reasonable decision maker have made all of those mistakes? That's where it gets tricky. And so we can have a scenario where any one ground of review doesn't necessarily give us unreasonableness, but cumulatively a whole stack of problems and errors in the decision making can give rise to unreasonableness in the decision making. So just being aware that there are different pathways or different ways at arriving at an unreasonableness argument. It is a fairly safe guess. You've seen the way that I write these tutorial problems. You've seen that I write assessment. It's a pretty safe bet that there will be multiple problems with the decision, or potentially multiple problems with the decision. And so that should immediately be making you think, okay, unreasonableness might be a further avenue, or there might be an unreasonableness argument that's opened up to us as well, on top of everything else that you identify. So just keeping that in the back of your mind as well. So those are, I suppose, some general comments about unreasonableness and when to use it and how to use it and things like that. Let's have a look at that in action, looking at our tutorial questions. So question 1, we're revisiting John and his air operators certificate application. We talked in week, I think it ended up being week 9, about some of the issues that might have arisen there in terms of the decision maker maybe making the decision for a purpose other than that which the power was given for, and also some issues around failing to consider relevant considerations and considering irrelevant considerations. Now we're looking on top of that, is there an unreasonableness argument to it as well? So as always, we'll skip is judicial review available for this one because we've already established that it is. So let's brainstorm some initial reactions. Do we think we've got an unreasonableness argument here, and why?
There's potentially, I think, a capricious use of power, where the reliance upon like a scandal, assertions of a scandal and reaching a decision are outside the statutory purpose of aviation safety, and that sort of indicates to me that the decision making is maybe using the power capriciously to justify some sort of vendetta or personal attack against Mr. Qantas.
Yep. So thinking about in the previous tutorial, we had concerns about the um, the purpose for which the decision was made, and now um, we can sort of extend that and say that, not only might, if we can establish that there were indeed problems with the purpose, um, it was actually the purpose that it was used for was a capricious use of power. Yep, I like that. What else?
I wasn't sure about this one, but I thought maybe there was a lack of plausible justification where um, he's talking about the fact that Mr. Qantas has no experience operating airlines in the Whitsundays, and that seems to indicate that he's taking into account irrelevant considerations in applying Section 28(1)(b)(4) of the Act concerning appropriate experience. So they seem to have taken into account a relevant consideration of experience flying in the Whitsundays. And further, they seem to have or failed to take into account the relevant consideration that Mr. Qantas has 10 years flying experience as a commercial pilot. So that's sort of a borderline on relevant and irrelevant considerations. But for me, I thought that might be also a lack of plausible justification.
Yeah, I can see where you're going with it, and I think on the whole, it's not a bad argument. The like I do quite like it. The thing that's potentially tricky, and we talked in week 9 about um some of the ideas around, why would the decision maker put such a narrow focus and narrow emphasis on the Whitsundays and experience in the Whitsundays? Is there something unique about that area where particular experience or expertise might be required or important for safety? And in our discussion, we suggested that, there's nothing on the facts that indicate that there is. Um, and so from the perspective of relevant and irrelevant considerations, we had a pretty strong argument. Where we then layer that onto the unreasonableness argument, I can see where you're going, and I think it's a good argument. What's potentially difficult for us is that it might be open to the argument that, sure, it's not the right call, but um, would no reasonable authority have looked at that? You can make the justification that, maybe there is something important about the Whitsundays, and a reasonable decision maker um, might have thrown that into the mix. And even though it's still wrong from that irrelevant relevant considerations perspective, as we've said, the unreasonableness, it's that higher bar. It's to a higher standard, and that makes it tricky. There's something else in the facts, though, that I think that we can use that sort of lack of plausible justification for.
Could that mean that they've used the wrong hanger? That they've identified the wrong hanger and they've made a few mistakes on that. So the authority for that would be Chen because he looked at the wrong file. And it's unreasonable for him to make a decision on something that he's got the wrong information on.
Yep, I think we could make a good analogy to Chen. As you said, they looked at the wrong file, and once you're looking at the wrong information, it just sets you off on a completely wrong path. And I think we'd have a good argument here as well. They've looked at the wrong hanger, and that's just completely, a reasonable decision maker is at least looking at the right information. That sort of draws us in some ways full circle all the way back to the no evidence ground of review that we talked about in week 6. That in particular is a ground of review where no evidence and unreasonableness arguments tend to cluster a bit more closely than some of the others. Just because good decision making or reasonable decision making is grounded in evidence and in the facts of the scenario, and so departures from that should immediately start to raise questions about the reasonableness of the decision making. It's not a one-to-one, and there can be scenarios where there is no evidence, but it's not unreasonable, but they're a bit more closely linked than some of the others. So that's a good pickup. So yeah, the key things to be thinking about on that one are the lack of plausible justification for the wrong hanger, and then also concerns about the capricious use of power, with concerns around the decision maker's apparent vendetta against John. That's really great to see. We will do a bit more structuring around scaffolding the answer, but I want to save that for the second tutorial question. So are there any other questions about this first scenario? No, excellent. Alrighty, let's move on to scenario 2, which is a new one for us. Here we've got Childcare Australia, a new government authority that's been established to oversee the national curriculum and early years framework. The Act provides for inspections, and in the inspection they're looking for particular things. Where there's evidence of non-compliance, the authority can issue a notice of non-compliance, and then they can also make directions in order to get the childcare centre back into compliance. Kylie runs a childcare centre in Sydney, and to about 30 children aged between 1 and 4 years old. She's got 4 staff members. There's an inspection, and they note that there are a few issues. The learning resources are not sufficient, and in particular, the issue is that there's only 200 books, and some of the staff don't have their PD up to date. The official invites Kylie to comment on those observations, and Kylie says, look, yes, we don't have as many books, but we go to the library all the time, so the kids get to access lots more books. And also there's another centre down the road that has even fewer books, but they passed their inspection. But she accepts that Anna and Bella would need to do more PD. She gets a notice of non-compliance anyway. And the key, I suppose, provisions are that, one, they have to buy an additional 400 books. They have to require staff members to complete more PD, and they have to suspend the provision of childcare services until they buy those books. Kylie's really worried because if she has to suspend the centre, she can't afford to buy the books. And then if she can't buy the books, she can't open the centre. So she wants to know, one, whether she can access further information. We can skip that one. This scenario is a bit of a hangover from when FOI was on the exam, so don't worry about that one too much. But if there are particular gaps in the information that you think we could clarify with FOI, we can make note of them as we go through. 2, whether judicial review is available, we should be well across that. And 3, if judicial review is available, on what grounds. So let's start off, as we always do. Is judicial review available? If yes, why?
Yes, it is available. It's made under an enactment. It's an administrative decision. It's definitive. It's final. And it's not excluded under any schedule. And then we're looking at federal legislation, so that's our jurisdiction. Yes.
Yep, nearly all of it. That's really good to see. We won't spend time on it now, but you know, for the perspective of exam preparation, just making sure that we're being detailed in our discussion. So, is it made under enactment? Yes, but being specific. It's a decision that's made under section, well, what was it, 6 of the 6 and 7 of the Childcare Australia Act. Is it an administrative decision? Yes, it is. How do we know? It's the specific application of policy to an affected individual. It affects her rights, etc., etc. So just providing a bit more meat on the bones, I suppose, of each of those elements. But really great to identify those. One more ingredient for judicial review availability. What is it?
Standing.
Excellent. Do we have standing here?
Yes, she's got a specific identifiable rights or interest in subject matter, and it's more than a mere intellectual and emotional concern, and affects her business interest in running the childcare centre.
Yep. Any cases that we want to throw to on that?
ACF and Commonwealth.
Yep.
In terms of being more an interest more than a mere intellectual emotional concern, and having a stake or interest in the decision, Onus and Alcala.
Yeah, I like ACF for the general test. I'd go Davis and Commonwealth for material interest, as in her commercial interests are affected. I mean, Onus and Alcoa is fine as well, because it's a case that also talks about standing. But in this instance, I think I just cut to the chase and go Davis. Excellent. All righty. So we've got judicial review. Great work there. Let's now talk about grounds of review. So we're going to do things a little bit backwards, just because of the nature of we're in week 11 and we want to talk about unreasonableness. We'll talk about unreasonableness first, and then we can circle back, and if there are any other grounds of review that we think apply as well, then we can talk about those as a follow-up. Normally I would, and it's your exam, you do whatever you want. Generally, my suggestion would be to save unreasonableness. If you're going to talk about unreasonableness, save it for your last one, because as I said, the cumulative sort of effect, if you save it till last, then you can use everything else that you've already said to help build on the argument that it was unreasonable. But for now, let's focus on unreasonableness. So let's be a bit more structured in our approach. So I've said it a lot, but what's the test or the standard that we're trying to get here in terms of unreasonableness?
So it's a high standard. You said narrow, like it's a very narrow field.
I did, yes. So you're absolutely right. It is a high standard. What is that standard? What are we trying to establish if we're arguing unreasonableness?
So it's a high standard in terms of it's not just you disagreeing with the decision because you don't like it. We are looking at the decision maker reasonableness in making the decision based on the information. So if we are looking at it, it says here they may. There was a word here. they may have regard to the following matters, and then they list all of this. So it's not, there's no minimum prescriptions that she has to adhere to. So
When you say she, do you mean Kylie?
intern.
Oh, okay. I see what you mean. Well, okay, we're diving into the specifics of this case. I guess what I'm asking for is the standard that we're going for here is, when we're making an unreasonableness argument, we are making an argument that the decision was so unreasonable that no reasonable decision maker would have made that decision. And so that's from Wensbury, the sort of the paradigm case. And so that's, when we're thinking about developing exam script and that sort of thing, that phrasing, no reasonable authority would have made it, that's got to be in there, because that's what we're trying to establish when we're arguing unreasonableness. And then, so, even beyond that, thinking about Marrickville Metro, we're trying to establish that, this is a demonstrably absurd decision. And thinking about Escher too, even if a decision is unreasonable, it might not necessarily be invalid. It's such a high bar, and so thinking about writing your exam scripts, that's your paragraph or your couple of sentences, running through those ideas and establishing that acknowledgement that this is a high bar that we're going to have to cross if we're going to successfully
Just repeat the
make
second case that you said.
Marrickville Metro. And these are all in the lecture materials and the study guides and that as
Yes,
well.
I just have to-
No. That's all good. That's all good. I'm just sort of conscious that, yeah, the specifics are all in that. So that's the standard. That's the goalposts that we're aiming for. And so from the perspective of scaffolding your answer, that's the place to start. Then from there, you could sort of talk about Fair's Rural Meat and think about these sort of paradigm cases or paradigm classes of decisions that might be unreasonable. And so, this is where we're thinking about lack of plausible justification, capricious use of power, or unequal or unjustified unequal treatment. These are not the only classes of unreasonable decision, but if we can fit our argument into one or more of these classes, then it sort of helps strengthen our case and sort of lowers the bar a little bit for us. So if we can slot ourselves into those paradigm cases, it's a good move to do that.
Can I ask a question, Jacob, if you don't mind?
Yeah, of course.
In the notes and everything, the decisions are likely based around the Migration Act, and the Migration Act didn't allow for unreasonableness, and that sort of brought in the illogicality and the irrationality. Does it mean in a different act, not the Migration Act, that you would only really have to consider unreasonableness if it hasn't been excluded? You don't really need to go into illogicality and irrationality. Would it make it easier or not?
Yes. I mean, it's a high, technically, yes, just because the Migration Act is itself such an isolated high bar in terms of, just everything about that act is just designed to make judicial review as difficult as possible. And so the unreasonableness is a high bar. Irrationality and illogicality, just steps it up even further. And so, yeah, technically, other acts where unreasonableness is not excluded is, easier. but it's, you know, it's sort of a 9 out of 10 difficulty instead of a 10 out of 10 difficulty kind of thing. Like it's they're questions of degree, rather than, you know, one being a vastly easier pathway than the other.
So if in this case you started off with the section 7, what it actually allows them to do, and they've gone that one step further to saying we want to close down the thing which is not part of the Act. So that would be the starting point, or like unauthorized decisions, or
well, and so this is partly why I'm saying we're doing things a little bit backwards here, in that you know, just to make sure that we cover everything in the time, I want us to talk about unreasonableness first, whereas normally you would talk about the other grounds of review first instead.
Sorry, I thought it was, you were saying we have to go through all the other ones to add up to unreasonableness. So
you don't have to add up to them, but it makes it more powerful if you can, right? So thinking about you can have a decision that is so unreasonable, and I'm thinking about Chen as a good example here. You can have a decision that is so unreasonable just in its own right that you don't necessarily need to add up a bunch of other things as well. I'm saying that there's sort of potentially there's two avenues that get you to unreasonableness. Sometimes it's just one catastrophically poor issue, or poor part in the decision-making process. Sometimes it's the accumulation of lots of little things that add up to it being unreasonable.
Okay.
And so, you know, from that perspective, structurally, if you talk about everything else first, then by the time you get to unreasonableness, if you've got the one catastrophically bad thing, you know, that's great. If it's a cumulative thing, then you've built it throughout your answer, so that by the time you get to unreasonableness, the case is that much stronger, because you can point back to, oh, remember that problem? That's not great. Remember that. A reasonable decision maker is not going to fail at every step in the decision making process. And so, yeah, from the perspective of writing an answer, absolutely, I would suggest that for the most part, you go about thinking about what are the other grounds of review that apply here, whether that's unauthorized, the decision not being unauthorized, whether that's irrelevant considerations, whatever it is. But for right now, we're just going to hone straight in on the unreasonableness issues. But you raise a good point in that, what do we think some of the problems with the decision are? So not necessarily attaching them to grounds of review just yet, but when you read this scenario, what leaps out to you as being problematic with this decision?
Well, one of the other problems I would have said is that she's ignored a reasonable excuse for not having the books by taking them on excursions to libraries, which builds self-confidence and teaches them how to use a library and still gives them access to all the learning books. Is that unreasonable?
Let's say there's the sort of the consideration of the access to the library, and whether that's something to factor in. Yep.
Unjustified unequal treatment, because the other centre has less books than her, and they've not been hit with the same I don't know, same closure effect or whatever.
Yep. Sorry, go ahead.
So I was just going to add it's similarly sized um, to the current one as well.
Yep,
It has
absolutely.
less-
So that's kind of the key thing when we're thinking about an unjustified unequal treatment argument. We need to establish one, what's the comparison between these two entities, whether it's childcare centers, whether it's radio broadcasters, whatever it is. Um, you know, how are these two entities treated, and how do we compare them? So, are these uh, are we comparing apples with apples? And then if we are, then how does the treatment compare? So can we establish that one has received treatment that's different from the other one? So the reason that's important is it's not just enough to say, oh, well, this other center doesn't has half as many books as us, and that was fine. If the decision maker can turn around and say, yeah, but they're only a quarter of the size, then it makes sense that there would be a different requirement for the number of resources and those sorts of things. So we need to be able to establish and draw some parallel between the comparators. In this instance, it seems like based on the facts, we probably can do that. So that they're what are we told? It's a similarly sized childcare centre, and it's down the road. So location, depending on um, depending on what the subject of the decision is, location might be a relevant thing. It might be an irrelevant thing. In terms of childcare, that's often something that's fairly geographically varies. So being able to point out that this is a similarly sized center, it's offering similar services in a similar location. These are two centers that you would expect would be treated the same or would be held to the same standard. And so when they're not, where one center gets told, oh, you got 100 books, that's great. And then the next center gets told, oh, you've only got 200. That's not very good. We're we're identifying that there is an unequal treatment or a difference in treatment there, and it's not clear to us on the facts that there's a justification for that difference in treatment, right? If there was something obvious in the facts that would justify why those centers should be held to different standards, then maybe there is that justification. But for our purposes and on these facts, it's not clear that there is a justification. These are two centers roughly the same, therefore we'd expect roughly the same treatment. Where that hasn't occurred, that's a problem. And you would expect a reasonable decision maker to be having that consistency in their decision making, where they'll give you equal treatment for equal comparators. Does that make sense? So yeah, just I suppose being alert to, it's not just, oh, here's two things that are different, or here's two people or businesses or whatever who have been treated differently, therefore it must be unreasonable. We've got to also have that check. Are they comparable, such that we would expect them to be treated the same or held to the same standard or whatever it may be? So yeah, don't in a scenario see different treatment and just go racing off. You need to have that extra check to make sure that that different treatment is indeed unjustified. What else might be problematic about this decision?
you could say under section 7, it says the directions given must be targeted at bringing the childcare centre into compliance. And if she has to close it down when she can't afford to send people on courses to get their abilities higher, she can't afford to buy the books. So it's yeah, technically it's unfair that way.
Yeah. So it's not so much that it's unfair, but it's the way that those conditions stack means that it's actually impossible to comply with all of them and still function. Is there a case that we can think of that's a little bit similar to? So we might be reminded here of the situation in Edelsten and Wilcox. So this is where the ATO was garnishing or taking funds to satisfy a debt, but they were taking such a great proportion of the funds that it was impossible to actually keep running the business, the GP practice. It was impossible to keep the business running while paying off those debts. And so, if the business falls over, then you can't actually pay the debt because there's no money coming in. So it ends up defeating the point of the decision in the first place. And so, thinking about those sort of paradigm cases, this is one where we can argue that this is a capricious use of power. It's not necessarily capricious in the sense of, it's the decision maker has a personal vendetta, but it's capricious in the sense of it's an overuse of the state's power. It goes beyond what's really needed. And here, the crushing weight of these Section 7 compliance directions is of the effect that the business will actually not be able to function. And so I think, we'd have a pretty good argument in parallel or drawing the analogy to Edelsten and Wilcox that, the effect of this decision, it means that they actually won't be able to continue providing the service. They won't be able to continue running the center. And so, that's unreasonable. A reasonable decision maker trying to, as you said, Ian, make a decision where, or make a direction that brings the childcare centre back into compliance, makes a decision that enables them to actually do that and come back into running as a compliant childcare centre. It's a reasonable decision maker is not making a decisions where the business effectively closes because it's impossible to comply with direction 1 and direction 3 at the same time. So it's the way that we sort of draw the parallel to Edelsten and Wilcox, and then scaffold in the arguments and the parallels as well. So we see where we're going with that one. Excellent. I want to circle back to the point around the library and the access to the library. I think that we'd have a good argument there that this was this was relevant information that the decision maker has failed to consider. Again, keeping Justice Mason's comments in mind, that we have to be very careful about deciding or dictating what a decision maker should or shouldn't have considered and how much weight they should have placed on it. We maybe start to get in murky waters there a little bit, just because the wording of section 5 is nature and condition of learning resources in the center. You know, they have done that, right? They've looked at, there's 200 books in this center. Let's park the argument that the 100 books down the road were fine. On the face, that's a relevant consideration that the decision maker is required to consider, and they have considered that. We've got the argument that, you know, the access to books through the library, through these visits, is something that is relevant. But I think it gets us, it's a little bit harder to say that it's unreasonable, because again, we're trying to establish that no reasonable decision maker would have excluded those books. You know, and that's tricky to do. You know, the decision maker might well say, you know, look, yes, the library, having the library down the road is great, but that's not a guarantee. You know, sometimes libraries get closed down. Sometimes they get moved to another location. Sometimes, you know, it's too hot or it's too rainy and you can't go to the library, or for whatever reason, these are not books in the center. And so, you know, we can't count on you reliably having access to them. And therefore we're not going to include it in our assessment of the resources that the center has access to. We might still, you know, be able to make the convincing argument that it was a relevant consideration and it should have been considered. But to say that no reasonable decision maker would have excluded that, it's just that little extra stretch that makes it a really difficult argument for us in that instance. So it's one that, if this was an exam question, I'd certainly be open to, well, I'd be open to two things. I'd certainly be open to the argument around failure to consider relevant considerations and the discussion there, including the nuance from Justice Mason's comments. I would also be open to the argument that it's unreasonable, but it would have to be very, very carefully made and probably come with, you know, the acknowledgement that it is not likely to be successful, right? Where you could say, look, you know, it's we could argue it, but given the high bar that I've just mentioned, it's a line of argument that we probably wouldn't win. And sure, we might make it, but it might not be successful. That's fine. You know, you've shown me that you have a great understanding of the law in this space. You've shown me that you can make a critical and nuanced application of the law to the facts, and you've arrived at a conclusion. It's a conclusion that is, you know, if you're representing Kylie, it's not fantastic. It's not where you want to be, but it's a conclusion that is probably right on the facts. That, I think, segues us nicely into a bit of an exam hint or tip and hint that I wanted to give you. And you know, you've waited long enough through the tutorial, so here it is. We're now drawing to the end of our consideration of grounds of review. We've just got remedies to think about next week. And so one of the things that you really want to be thinking about is how do these different grounds of review layer together? How do I, in an exam scenario, decide which ones I'm going to talk about? You can think about grounds of review in sort of different, I suppose, classes. The first class would be grounds of review that are clearly relevant and would have a strong chance of success. The next are grounds of review that are clearly relevant, but it's borderline whether it would be successful or not. The third class would be grounds of review that are clearly relevant but would be unlikely to succeed. So, for example, in this scenario, where is it? The official invites Kylie to comment on these observations as part of the inspection. You read that line and you think, okay, she's been provided with natural justice, right? We think about the hearing rule, evidence, notification that the decision is going to be made, information about on which the decision will be based, and an opportunity to comment on it. She's been given that. That's great. So that's when we think about, okay, well, she's been given natural justice. That's a ground of review that's relevant, but not going to succeed. Sorry, did I freeze up there?
And we
Okay.
didn't-
Sorry, go again.
Didn't get it at all.
Okay. Where was the last bit? I was probably talking about this sort of third class of decisions that are relevant but not going to succeed. Yep. Okay. And in this scenario, we've got one of them in natural justice, right? Kylie has been given natural justice. She's been given an opportunity to comment on the information before the decision's made. But, so it's relevant to us in that you read that and you go, oh, that's that sort of makes me think about natural justice and that ground of review. It's not likely to succeed. And then the fourth category would be grounds of review that are not relevant and therefore not certainly not likely to succeed because they're not relevant at all. For the exam, you would want to concentrate your efforts on certainly the first two. I'm open to the third. So if it's not relevant, don't feel the need to talk about it. That's the fourth one. If it's relevant and you've got a strong chance of success, obviously you want to talk about that. If it's relevant but maybe it's line ball, whether the argument gets up or not, feel free to talk about that. But what I'm looking for is a realistic assessment of the chances, right? A client wants to know, they don't want an optimistic sense of, oh yeah, I reckon we'd do that and it'd be fine. They want a realistic assessment of, look, we could make this argument, but here are the things that would count against us. Here are the arguments that would the reasons why that argument might not be so strong, or here's why the facts rebut what we'd be trying to argue. Include that in the discussion, and then that way you've demonstrated you know the law and you know how to apply it to these specific circumstances. The third one, relevant but not likely to succeed. I'm open to it. It's not, it's not the best use of your time, but I'm open to that discussion. So, you can raise it, but you'd have to think, are there better things that I could be talking about in this exam response? The big hint, I've said before, you got 3 questions. Question 1, is judicial review available? Question 2, what grounds of review are relevant and might succeed? Question 3, what remedies are available? Question 2, so grounds of review, you're going to be asked to pick 3 grounds of review to discuss. That doesn't mean only pick 3 grounds of review from the last few weeks and study those, because that's a big roll of the dice that not all those 3 will pop up in the scenario. So, you still need to be across all the grounds of review that we've talked about. But in the exam, you will pick 3 that you'll discuss. Whether you then, choose to talk about, one that's a strong chance of success, one that's line ball and one that is relevant but won't succeed, that's up to you whether you go for like, here's the 3 strongest ones. I'm open to those different breakdowns, and that's fine. But knowing going in that you're going to talk about, there will be more than 3 that potentially apply or arise, but you only need to pick 3 and discuss 3 for the exam. Any questions about that little hint? So as I said, don't just only study 3 grounds of review and gamble that those will come up, because there's a good chance that they won't all be there. But yeah, hopefully that under the time constraints of, working on the exam and budgeting your time and those sorts of things, we'll talk about that in a lot more detail next week. You'll have a bit more of a solid structure to plan your time and plan your answer and things like that.
So there's one scenario,
Yes.
and those 3 questions, and out of
Yes.
that scenario, you got to pick the best 3 grounds.
Best. I'm going to say you pick the best 3, but no, not necessarily. The best 3 to showcase your knowledge and understanding of administrative law. So that might be, you might demonstrate you've got a really good understanding of administrative law by identifying, look, here are the 3 clear ones. These are 3 winners. We'll go with them. You might equally say, look, here's 2 really good ones. Here's a 3rd one that's a little bit outside the box. It's a creative answer. It's 50-50 whether we succeed, or it's, it turns on these couple of things that might be hard for us to prove. But if you can present that discussion in a nuanced way and with good reference to the key principles and case law and things like that, that answer can do just as well, if not better, than an answer that just goes for, okay, well, here's the 3 easy, obvious ones. So yeah,
Okay.
three best doesn't necessarily mean 3 most obvious ones. But it's pick 3 and talk about them.
And after what we learnt tonight, are we supposed to take those 3 grounds and try and identify unreasonableness, or is that an option, or is that not part of it?
Your 3rd one might be unreasonableness. And that's, that's fine. If, and here's the other thing, right? Is like, you don't get penalized for the things you don't talk about, in the sense that, let's say you picked 3 other ones. I'm not going to sit there thinking, oh, why didn't he talk about unreasonableness? If the other 3 are really good, then, it doesn't matter that you didn't pick unreasonableness. If you've got 2 and then your 3rd one's unreasonableness, that can be great as well. That made me think of something else about, you don't get penalized for the things you don't say. Obviously, if you only pick 2, and you don't talk about a 3rd one, then that's going to be a problem. But yeah, you don't lose marks for like missing a ground review, as long as you've talked about 3 and done a good job on it. We're closing in on 8 o'clock. Any final questions or comments?
So it's 9 o'clock in the morning.
Yes, 9. So Queensland time, 9 a.m. till 11:30. And really, the 9 a.m. is 8:45 a.m. because you need to be in the Zoom room early enough for ID checks and things like that.
And next week's going to be review again?
Yes. So next week is remedies. I want to there's a few things that we have to talk about for remedies, but I want to run through that as quickly as we can to make sure that we've got enough time for revision, general exam tips, things like that. So I think I said last week, if you've got specific questions or specific things that you really want us to recap, please email me so that I can make sure that we budget enough time to cover all those things. But yeah, revision, remedies and revision next week. Excellent. Well, that's a great note to end on. See you all next week. Plenty more exam discussion, couple more exam hints maybe. So looking forward to seeing you all then. Thanks very much. Have a good week.
Thank you. See ya.